This is lecture number 6 for the immigration training, the 6 hours training program. This is the last lecture of your 6 lectures included in this training program. And after this lecture, you are going to take a final examination. So during this lecture, we're going to look at talk a little bit more about sight translation. We started talking about sight translation in lecture number 5. And now we're going to finish with that. We're going to be talking about professionalism and protocol in the courtroom. I'm going to be playing several practices for you to get ready for your final examination. They are all going to be the simultaneous ones will be at 160 words per minute. Then I'll give you some information about what you need to practice in the lab, how to prepare for that final examination, okay? And then we'll finish with this lecture. Now, in lecture number 5, we were looking at sight translation, and if you recall from lecture number 5, we were looking at the style, the pace in the delivery, and in terms of the style, we mentioned that you should not pause unless there is a period. And the pace, we mentioned that each paragraph should have its own pace, or all of them can have the same pace, but it doesn't have to be that way. You could definitely have one paragraph with a given pace and another paragraph with another pace. And the key was that that the pace for each paragraph had to be uniform. Okay, nothing like the judge told me that you should come to court because there is a notice to appear that was filed by the U.S. government against you. That's not a good pace. Should be more like the judge told me that you should come to court because there is a notice to appear that was filed against you, or that the government filed against you. So, you have to have the same pace. Now, the pace should be such that you have to be able to finish the sight translation, the document, within a period of time, usually 3.5 minutes or so. Now, today we're going to look a little bit about what we call backtracking, which also falls into style, and then we'll look into structure and what's the role of the actual structure in the sight translation. Now, backtracking is defined as when you say something and then you correct yourself and then you change that pretty much. So, for example, the judge told me that their U.S. government, and then you backtrack and you say that DHS. Which basically is the same, but you backtrack to really change something that was almost the same. So that type of backtracking is not advisable. Now, you do a backtracking when you know you made a mistake, a substantial mistake, obviously, that changes the content, the message. That you do, because otherwise you end up with a segment that is not accurate. But if it's just a matter of choice of words, then it's not that critical, not at all, okay? So don't do any backtracking. If you say, for example, one word and then you want to change it to another word that means the same thing, but it might be more fancy. Well, that's not a good idea to backtrack for that purpose. But if you say, for example, my niece, and then it was actually my nephew, then of course you will backtrack if you have to, okay? Now, in terms of structuring, different languages have different structures in terms of how you create a sentence. And a sentence is nothing else than a message. So there are some languages that match the structure of English close enough, but there are other languages that do not. Those languages that have structures that are very different, and what I mean by structure is the word order. English tends to have a pronoun and then the subject and then the rest. Other languages may have the rest, the pronoun, and the subject, or whatever the case is. So depending on the language, on the foreign language, you will find that the structure will be different. In those languages where the structure is very different than in English, obviously my advice is that you deliver at a slow pace, but not too slow that you don't finish within the 3.5 minutes given to you in the final examination, or not too slow that you take such a long period of time in court that they're just waiting for you to deliver. So yes, it's true that structure plays a critical role in the transfer. The rule of thumb when it comes to the structure is it doesn't have to necessarily be perfect. I mean, it will be ideal if it's perfect. But if the restructuring is done in such a way, or if your product is has a structure that may not be perfect, but yet it conveys the message in a very good way, in a normal way, it doesn't sound awkward either, then that's sufficient. This is not written translation where you have all the time and you can read the translation and go over it and correct here and correct there. This one, you have to decide within, really a couple of seconds how you're going to restructuring this if restructuring is necessary. So it's important that you always keep in mind when you transfer into the opposite language that the sentence should have a structure that conveys a meaning that makes sense, okay? And that doesn't sound awkward. What we don't want, of course, if you go from English into the target language, you don't want to be using target language vocabulary, but have the same English structure, unless in both languages the structures do match. But in general, sometimes they don't match 100%. Because then it sounds like, it sounds like a foreign language, but it keeps the original structure, which in turn may make the message may be a little bit awkward. And not only that, maybe the message is not accurate at all. So the portion of structure is really important in your site translation component. And when you're given 2 minutes to read, or a minute and a half to read the site translation, and by the way, in the court, we'll talk about the protocol in the court of law, how you handle this requesting more time and all. We'll do that in a few minutes. But in the final examination, you're going to be given a certain period of time to read it and a certain period of time to deliver. During that period of time, you should really pay attention again to the structure and also to the vocabulary. Now, in this particular lecture, for your lecture number 6 in your manual, you will find that there is one document, and this is under lecture number 6. I'm looking at your table at the contents on page 3, and it says Lecture 6, Advisement of Rights, and then it says commonly used EOIR acronyms. So let's look at what's in this lecture. Right. So you have the Advisement of Rights. What are you supposed to do with this? Okay, this is more like a type of a homework thing that you want to do. So that you are better prepared for your final examination, and also that you do some type of research on your own. It's very important for an interpreter or a translator to do research on his or her own by looking up words in the dictionary and so on and so forth. Well, in this particular case, I'm giving you this site translation, which is a very common one. This may be in immigration court. You may do this as a site translation, but most likely you're going to be interpreting this simultaneously. There's very, very little, if any, site translations in immigration court, okay? But the content of this particular site translation, Advisement of Rights, is very applicable to immigration proceedings because you may hear all this verbally. The judge advises the respondent of all these rights. That's way more common. But what I would like you to do once we finish with this lecture is to go over this Advisement of Rights and actually do a written translation of this. Just look up the words that you don't know. Many of these words, you probably know them already. We discussed them here in class. You were given the proper translation and so on and so forth. But if not, just look for a dictionary. Look up the word in a dictionary. Look up for a proper transfer, and do a written translation of this, and become really familiar with this material. Okay. Now, once you've done your written translation, then make sure you remember what is the corresponding transfer for each of these sentences. And it's a good idea not to write on the original. Write on a separate piece of paper, or you can print out these pages again, and you can use that as a, like a workbook or pages to write on it. That's perfectly fine. But I do want you to have this side translation without any notes available. So after you do the translation and after you create flashcards and after you really know all the terms or all the structures, I want you to go back and record yourself while you're actually doing this side translation without referring to your notes and to your own translation. So you will go back to this, the advising of rights, and then you will, it says counsel of choice, then you will say that in the target language. And then you have the right, and as you read it, you will say it in the target language. Of course, you will use remember the material that you already use, or the vocabulary that you use when you did a written translation of this. And you do the whole, it's a page and a half almost, and I want you to do that, to record yourself and check on your style, whether you pause when there is a period only, whether you hesitate, whether you backtrack, whether there is uniform flow. Those are the things that you need to check, okay? So that's sort of the homework for you after you complete this lecture. And you should do this right after you complete the lecture if you have the time to do that. Now that lecture also, that material, after the side translation, in that lecture, you also have the commonly used EOIR acronyms. Executive Office of Immigration Review, which you probably have seen it already, but just in case. What's a very good practice for you before you take your final examination is to actually make a copy of these two, and you can actually do that also in your class manual. And next to the term, like A and the number sign, it says alien number, then you write next to it the term in your target language. What's the translation for that term, alien number? BIA, Board of Immigration Appeals, right next to it, what's the translation for Board of Immigration Appeals? Many of these things have already been translated for you, but if not, you research them on your own. They're not too complicated. And now the question, of course, is what is the protocol in immigration when you hear an acronym? And we're going to talk about that shortly. But what I really want to make sure is that you do know the translation of all these definitions. What alien number? What's the translation into a target language for that? What's Board of Immigration Appeal? What's the translation for that? What's the translation of Convention Against Torture? What's the translation of Customs and Border Protection? And you need to create flashcards and you need to study them before you take your final examination, and certainly before you do if you do pass your final examination, you're successful in passing this training program, before you actually do your first hearing in immigration court, okay? Very important, because these are very important, very commonly used acronyms. Now, that's pretty much the material. Now let's talk a little bit about the lab, and then we're going to be talking about professionalism and protocol in the courtroom, and do some practices, and then finish with this lecture. Now, in the lab, if you go to the table of contents in your lab, the contents is on page 3, but you're going to have to turn the page because the practices that are to be completed after finishing lecture 6 are actually listed on page 4. And you have, several practices there that you have to complete. And you should do those practices, all of them, in preparation for your final examination. You have many practices to complete there. So you should go to the lab and you should do all those practices. And they're all, you can see the simultaneous are all at 160 words per minute. You should do all those practices, and then you have the scripts. So you can review the scripts if necessary. And the best thing, this should be used as an evaluation tool. So you record yourself for each of these practices without referring to the script. Pretend you're actually taking the real exam and the final examination. So you won't be able to have a script. So you do all these practices, you record yourself, you listen to them, and you will realize that there is one part that you need more work than others. So say, for example, that you need more work on master calendar hearing, then you go back to the section of master calendar hearing and you can practice them, all the practices that are available. Or statement of the law, and the same thing, okay? Or if it is the individual merits hearing, do the same thing, okay? And there is also a side translation for you to practice different than the one that you work in class, or the one that is presented to you in class. And of course, you can, that site, you try to do that with that site translation without having any prior knowledge, record yourself, and if necessary, go back and translate it, and really learn all the vocabulary for that site translation. And then, of course, you can try to do that again. So if you're going to be working with that site translation, if you're going to be looking at different terms and so on and so forth, then make sure you do have a clean copy so you can go back later on once you have decided on what's the proper translation for all these terms. Then you can go back and actually record it again and check the style of delivery, okay? So those are the practices you need to complete, but they are not just the only practices. Because your final examination is probably coming up pretty soon, practice as much as you can in all the sections of your lab, okay? Not only on those practices that are to be completed after finishing lecture 6. You may want to go to lecture 5 to between 5 and 6. You may want to do all of them if you want to. The more practice you get, the more the chances of passing that final examination. Particularly practices at very fast speed. Concentrate on 160 mainly. 145, but 160 is where we're going to be testing you, okay? So that's really important. So that's pretty much the assignment. And now let's talk a little bit about professionalism and protocol. Besides interpreting, we are just not only interpreting and conveying a message from one language into the other, from English into a target language, but we are also representing an entity. We are representing a profession, and as such, we need to we need to be professionals in many ways. When we talk about being professional, what are we talking about? Well, the first thing when you think about professionalism is the way you dress, your attire. That's very important. Your shoes. You can't just go, like there have been many complaints that people actually wear tennis shoes or sandals to go to work. Just dress professionally, okay? This is for the ladies. For men, sometimes there are complaints that men do not go with a tie. And you may say, well, some attorneys don't go with tie. Well, that's irrelevant what the attorneys do. What's relevant here is what you do, because you're representing the whole profession, and you have to somehow be professional. If you want them to respect you, you have to respect yourself, and the best way to respect yourself is to be professional, dress professionally. What that means when I say professionally is that if you're a male, you should have not necessarily a suit, but definitely a jacket and tie and formal type of attire. For females, then businesslike. Okay, that's very important. So that's the first step. The second step is that you don't want to show up to court late. Neither do you want to show up right on time. And you have to keep in mind that in many of the immigration courts, you do have to go through sometimes there's a security check, sometimes there are elevators and you have to wait a long period of time. There are certain things that will take time. So if you're supposed to start at 8:15, for example, make sure that you are already in the courtroom at 8 o'clock. You will have to be perhaps sometimes preparing equipment, making sure the equipment is working correctly, because these proceedings are recorded. So you need to make sure that the headsets are available, that everything is in place, and don't show up just right at the very last minute. That's not very advisable. The other thing that includes professionalism is how you behave in the courtroom. You will find that there are judges sometimes, they get to know you and they are very informal with you when they talk to you, but when they are not on the record, when they are not dealing with a case. And sometimes interpreters think, he is or she is very nice with me, so I don't have to show that much sign of respect. Well, maybe not when you are not interpreting for a respondent, when you're in an informal setting, when you're not on the record. But when you are interpreting for a respondent on the record, that judge is representing immigration and all the immigration judges. And therefore, you have to be very, very formal and very, very respectful of that. So things that, you will have a certain protocol to address the judges in court, which I will explain in a few minutes, and you cannot deviate from that protocol. Extremely important, because the misunderstanding sometimes with the interpreters is that, oh, but the judge is always so nice to me. Why I don't, I can laugh if he laughs while he's on the record and stuff like that. No, on the record, you don't have to. All you are there is just to interpret. It's not an informal setting. It's very formal because you're on the record. Now, once you're off the record and, the judge wants to make this an informal setting, then that's perfectly fine. But you must always project that image that you are, professional, and most important of all, that you are not biased. And by that I mean, excuse me. When I say that you're not biased, I mean that you're not trying to help one party or the other party. And this brings up an interesting thing. Sometimes you will be sharing an elevator with perhaps an attorney that you work with, a government attorney, or an attorney for a respondent that you know. Try not to have any type of communication if at all possible. Do not establish any type of communication, because in the same elevator, there might be family members of the respondent or the attorney for the respondent, and there shouldn't be any type of communication with the U.S. attorney. If he says, hi, how you doing? It says, hi, and that's it. Don't continue with the conversation. This is because the professionalism does not only begin when you are interpreting in the courtroom, it begins when you walk into the building. And that perception of being biased because you're communicating with this person and maybe you're trying to help them, or God knows, has to be completely eliminated. So no communication, no dealings with the attorneys. You're not, the attorneys want to give you translation work and stuff like that. You can't do that because you are actually working as somebody working in immigration court. So definitely not exchange of jobs, work, money, or anything like that. That's completely unethical. Now, the other thing that also comes into professionalism is the fact that how we behave with other interpreters. And it's important that, you may have some friends that are working, because you're working almost every day in immigration court, and so you have some people that are you feel more comfortable with. Of course, you can talk to them, but, keep it at low tone of voice, not screaming. You're not the manager of the building. Neither are you supposed to be directing people where to go or anything like that. That's not your function. And you're supposed to have a conversation. If you want to have a conversation with your coworker, that's perfectly fine. But never talk about cases, or never talk about anything that deals really with a case that you have already interpreted for, or talk about judges, or talk about other people. Really try to keep this professional even among your coworkers, because they will respect you if you do that, okay? And you will meet wonderful people in immigration court, people from different cultures that will enrich you as a person by knowing them and understanding their culture. But what you don't want is to have any type of issues because you are being too loud, or you're sort of ordering other interpreters what to do or what not to do, because you work there every day and this interpreter just shows up and works only maybe once every 2 weeks, and you feel entitled that you can do all those things. No, you're all at the same level, and you should all exercise the necessary professionalism. Very, very important. If you want to be treated as a professional, act as one. Very, very important, okay? And it's not only the person you're talking to, which could be a coworker. Remember, there might be other people around you other co-workers or other people that work in immigration court, judges, attorneys, or people that are staff interpreters, whatever the case is, that they are looking at you and see how you actually behave. And it is important that you always project that professionalism, that it is so critical. All right, very, very important. Now, that's professionalism. What's protocol? When we talk about protocol, protocol means the things that you must do in a courtroom so that it sounds professional. For example, if a judge gives you a side translation, which is going to be very rare, but let's say that the judge received this document from a given country and is written in the language that you speak, and the judge wants to know what it means. So the judge gives that to you, then you will need some time to read it. Let's say it's a page and a half. So the way you will address that is you will say, Your Honor, may the interpreter read this for 3-4 minutes to become familiar with the document. May the interpreter read this for 3-4-5 minutes to become familiar with the document. If the judge asks you why, they will say, well, because the structures are not equivalent, and before I render this into English, I need to fully comprehend the source and the structures and all that. So you have to explain why. The purpose why you need 3-4-5 minutes is so that you do a better job, so that you're more accurate. But the format is may the interpreter is asking that question. Now, it's like asking the judge permission to do something. If you are, for example, interpreting for a witness, or maybe for the respondent as well, you can be interpreting for another witness, like the respondent's spouse, for example, and for the respondent. And let's say that the witness uses a term that you are not familiar with, then what you will have to say is, instead of making things up, remember, we cannot be talking to the respondent or to the witness. We're just there to transfer messages from one language into the other, back and forth. So you will, if somebody uses a word that you're not very familiar with, you need to ask that person what that word is. You can't just turn and ask the question. You have to ask the judge permission to have a conversation with that person. And the way you ask the judge permission to have a conversation with that person is by asking the judge the following. Your Honor, may the interpreter inquire. Your Honor, may the interpreter inquire. And what you're really saying when you said, Your Honor, may the interpreter inquire, you're really saying, Judge, I don't understand very well what this person is saying. There's a word I don't understand. That's what it really means. And I need to ask him a question. Some judges may not know what it means when you say, Your Honor, may the interpreter inquire. And they say, why do you need to inquire? And then you will say, then you will specify why. You specify why the witness or the respondent used a term that the interpreter is not familiar with. And then the judge will give you permission. When the judge says, yes, go ahead, Madam Interpreter, then you turn to the witness or the respondent, whoever is testifying, and you say, sir, when you use such and such word, you speak in your own language, obviously. What actually are you referring to? Can you give me another... Can you use other words or whatever until you realize what the message is? Because you may not know the meaning of a given word, but you really need that to deliver the message. And that's the bottom line is for you to know what the message is. And once the person tells you that, and you are satisfied that you understand the message, you say, thank you, Your Honor, and then you interpret. Now, in another thing about protocol, you may hear, because this is recorded, you may also hear many judges, when they address the respondent, that they say, to the respondent. It's very common, so that it gets recorded that whatever the judge is saying is telling that to the respondent. That expression, to the respondent, doesn't need to be interpreted, obviously, because you're interpreting for the respondent anyway. You interpret what the judge says. For example, let me give an example. It says, to the respondent, when did you come to this country? And then the interpretation into the target language will be, when did you come to this country? You do not interpret to the respondent, okay? That's important to keep in mind as well. Now, judges may ask you to do certain things in the courtroom that you may find that is not the job of an interpreter. Sometimes judges ask you, for example, to distribute paperwork to the people that are, to the respondents in a master calendar hearing, or whatever the case is. you have to cooperate because you're working as a team. Okay, so you can't say no, because remember, some immigration courts do not have clerks, or they have a limited number of clerks, and they do need some help from the interpreter, from anybody that it is working in immigration court. So you're part of a team, and you shouldn't feel bad about that. You should cooperate, because if you don't cooperate, then they feel that you don't want to be part of a team. So don't be too arrogant. Oh, I'm the interpreter here. That's it. You know, I'm somebody who's special. No, you're not special. You're just a part of a team, and you do a job that is essential to basically the administration of justice, and also in this case, essential for the immigration court, because otherwise the respondent doesn't understand what's going on, and immigration court or the judge doesn't know what the respondent is saying. So yes, it's a very important job, but so is the job that the judge is doing, and the attorneys. So we all have different tasks that we have to do, and sometimes we are asked to be a team player, and to work as a team. And in those cases, sometimes they tell us, can you distribute this paperwork? Can you give this? And you should be more than happy to do that. Always, with a smile, of course, not just making comments like, well, I'm an interpreter here, I'm not a clerk, and things like that, because that will guarantee that they will not like you. Why do you want that? Why do you want to create a negative atmosphere there when in fact there is none? Just make sure that you get along with the people that you are working with. That's really, really important. In terms of protocol, another important thing is that you shouldn't be talking to the respondent before, during, or after. All you're there is just to interpret. All right. No, you shouldn't be talking to the attorney. Now, sometimes what happens is that the respondents, sometimes in some bond hearings that they do this through video. Sometimes there is some conversation going on there. The judge talks to the attorney for the government, and the interpreter is there, and sometimes the judge asks questions to the interpreter. It's very informal because nothing is happening. The bailiff is actually putting everybody organizing everything in the detention center, and if they talk to you, you answer, obviously. But as soon as it's on the record, you keep always the same professionalism and use the protocol that was discussed here in this lecture. Okay. All right, so next thing we're going to do is I'm going to be playing 4 different practices now that is sort of a preparation for your final examination. Doesn't mean you're going to get exactly the same thing, no, but it's a good practice. And again, as I told you earlier, record yourself, determine which are the areas that you need to work on, and go to the lab and work on those areas. So you're going to hear the first 2 will be 2 master calendar hearings. You're going to have all 4 practices in a row. The first 2 will be a master calendar hearing at 160 words per minute each. The third one will be a statement of the law at 160 words per minute. And the fourth one will be an individual merits hearing. It's testimony, so you need to use the consecutive for the last one, okay? Now, you'll do all 4 because what we want to do is we want to see how you perform, and for a prolonged period of time. This is going to take about only 22, 23 minutes, which is approximately half the duration of your final examination. Your final examination is about 50 minutes long. And we'll briefly discuss this after this practice, what the final examination entails, okay? But now I would like you to start doing these practices, record yourself. Once this lecture is over, listen to the recording of all these practices and determine, oh, I need to work a little more on this, a little more on that, and then go to the lab and, of course, complete the practices that correspond to after completing lecture number 6, but also go to previous lectures or different other practices that are in the lab so that you can continue practice and getting ready for your final examination. So here are the 4 practices in a row. The first 3 simultaneous, the last one is consecutive. Here they are.
Master calendar hearing at 160 words per minute. Case 332. This is a continued preliminary hearing before Immigration Judge Sandra Kim at Los Angeles, California on January 29, 2016. Case number 847-892-02332. So, what do we have here? Are you filing an I-130? The respondent was going to get married to a U.S. citizen 3 months ago, but the doctors discovered that the respondent's son has cancer, and the respondent had to go back to the respondent's birth country to take care of the son who resides there. Therefore, Your Honor, the respondent was unable to file an I-130 since the respondent did not get married yet. I understand that the filing was not made, but the respondent also has an asylum application on file. In the alternative, he does not file the I-130. That is correct, Your Honor. I will set for a hearing in about 9 months. If the I-130 works out, then I will be happy to look at an adjustment. What about November 18th, 2016? That is fine, Your Honor. Homeland Security? That is fine, Your Honor. You must come back on November 18th, 2016 at 8:30 a.m. If you fail to come back, I will hold the hearing and you could be ordered removed to your country of birth. Counsel, please make sure his fingerprints are up to date. Yes, Your Honor. The interpreter will hand you a blue form, a change of address form. Make sure you file that form within 5 days from your change of address. Otherwise, Homeland Security may arrest you. Any questions? Nothing further, Your Honor. No, Your Honor. Case is adjourned. Master calendar hearing at 160 words per minute. Case 279. Before we go on the record, the respondent has 2 children, right? Yes, Your Honor. What are their ages? 3 and 7 years old. I will waive their appearances for the next hearing. On the record now, Ms. Collins, does your client have an asylum application pending? Your Honor, the respondent prepared the application on her own and actually did a good job. But there are some typos, and I would hesitate to submit it today before I go over the application. Furthermore, I did not participate in the preparation of the application at all. You are now represented by Ms. Collins. It is not wise to do your own filings. You have to let your attorney help you, and let her do the filing for you. You are paying her good money, and her job is to help you. I do have to admit that at least you had the initiative of preparing it on time. I will give you more time so that your attorney will have sufficient time to go over the application with you. Counsel, I cannot give you a date for about 8 months. There is a new policy that will allow you to file the application downstairs in the reception, and that filing will start the clock. But that is optional, right? Yes, it is. You can also submit it in the next hearing if you prefer. Okay, what about October 21st, 2016? That works for me. It is fine, Your Honor. Also, I will waive the presence of the 2 children in the next hearing. You must come back on October 21st, 2016 at 8:30 a.m. If you fail to come back, I will hold the hearing and you could be ordered removed. Yes, Your Honor. The interpreter will hand you a blue form, a change of address form. Make sure you file that form within 5 days from your change of address. Otherwise, Homeland Security may arrest you. Any questions? Nothing further, Your Honor. No, Your Honor. Case is adjourned. Statement of the law. To be eligible for cancellation of removal under Section 240AA of the Immigration and Nationality Act, an alien must demonstrate that he has been lawfully admitted for permanent residence for not less than 5 years. He has resided in the United States continuously for 7 years after having been admitted in any status and has not been convicted of an aggravated felony. As was explained in matter of CVT Supra, factors pertinent to the exercise of discretion under Section 212C are equally relevant to the exercise of discretion under Section 240A of the Act. For example, favorable considerations include such factors as family ties within the United States, residence of long duration in this country, particularly when the inception of residence occurred at a young age, evidence of hardship to the respondent and his family if deportation occurs, service in this country's armed forces, a history of employment, the existence of property or business ties, evidence of value and service to the community, proof of genuine rehabilitation if a criminal record exists, and other evidence attesting to a respondent's good character. Among the factors deemed adverse to an alien are the nature and underlying circumstances of the grounds of exclusion or deportation, now removal, that are at issue, the presence of additional significant violations of this country's immigration laws, the existence of a criminal record, and if so, its nature, recency, and seriousness, and the presence of other evidence indicative of a respondent's bad character or undesirability as a permanent resident of this country. In some cases, the minimum equities required to establish eligibility for relief under Section 240 AA, for instance, residence of at least 7 years and status as a lawful permanent resident for not less than 5 years, may be sufficient in and of themselves to warrant favorable discretionary action. However, as the negative factors grow more serious, it becomes incumbent upon the alien to introduce additional offsetting favorable evidence. With respect to the issue of rehabilitation, a respondent who has a criminal record will ordinarily be required to present evidence of rehabilitation before relief is granted and as a matter of discretion. Statement of the law. Consecutive practice. Individual merits hearing. Counsel, please state your appearances for the record. Carla Romans, representing the U.S. government. Sarah Lewis, representing the respondent in this matter. Can the respondent hear the interpreter clearly through the headphones?
Yes.
Do you understand the interpreter?
Yes.
If at any time you have difficulty understanding the interpreter, please let me know immediately.
I will. Thank you.
You previously took an oath that the testimony you will provide in these proceedings will be the truth, the whole truth, and nothing but the truth. You are still under oath. Do you understand?
Yes.
The attorney seated next to you has entered an appearance in your case. Do you want him to represent you in these proceedings?
Yes.
Where are you currently living?
$290 North Collins, apartment 1H, Miami Beach, Florida.
You are being provided with the blue change of address form. If you do move at any time during these proceedings, you must complete a change of address form and file it with the court within 5 days of moving. Do you understand?
Yes.
Counsel for the government, are the necessary biometric checks completed and current? Yes, Your Honor. Very well. Counsel, you may begin with the examination. When did you come to the United States?
I came about 10 years ago with my family.
When you say my family, can you please elaborate on who they are?
Yes, I came with my mother, my father, 2 sisters, and my little 8-year-old brother.
Did you come illegally into the United States?
No, we came with a tourist visa, but we overstayed it.
Why did you come to the United States?
My father was persecuted by the police because he's a human rights activist, and the government had it in for him.
What do you mean when you say the government had it in for him?
I mean that the government wanted to kill my father and my mother for being activists. In fact, they came to our home many times looking for my father. We all knew that they wanted to arrest him and torture him.
Who are you referring to when you say they came?
I'm referring to the special forces of the Government Protection Unit.
What is that unit about?
The Government Protection Unit is in charge of raiding houses of what they call unfriendly enemies.
What is the definition of an unfriendly enemy?
Anyone who opposes the government is an unfriendly enemy. No matter the degree of participation in the opposition, the government treats everyone the same. They simply torture and then kill them.
Did they ever get a hold of your father?
No, they did not. The reason is that my father was tipped by someone in the government that this unit was looking for him to interrogate him about other members of the opposition movement.
And what did your father do?
He gathered all of us in a living room on a cold evening and told us that we were going to leave the country. He told us that he was able to obtain a visa from a friend who was working in the US embassy, and that we were going to leave the next day at 2 p.m.
And did you leave your country to come to the United States the next day?
Yes, we did.
The government has showed evidence to the judge indicating that the government who persecuted your family was no longer in power and that the new government was more lenient with the opposition. What can you tell us about that?
That is not true. The only thing that changed was the president, or rather the dictator. The government follows the same principles, ideals, and tactics when it comes to the opposition. I assure you that such evidence is not accurate.
Your Honor, we would like to submit a report prepared by the U.S. State Department indicating that the situation in the respondent's country of birth is still very volatile and that there were no major changes in the policy implemented by this so-called new government. This report is marked as Exhibit R29. Proceed. What would happen to you if you were to return to your country of birth in the next 6 months?
I would be killed. They already know who I am. They would first torture me to know where my father is, and then they would kill me. I have no doubts about that.
I have no more questions, Your Honor. Thank you. You may step down. Let's take a 5-minute break before we continue with the next witness.
Okay, so now that you have done all these practices in preparation for your final examination, let's talk a little bit about that final examination. When you sign up to, when you schedule your final examination, you also had the option to download the candidate's handbook, it's called, where you have an example of what the final examination entails and also the way you will be graded. So please review that so that you're familiar with how you're going to be graded. Make sure you pay close attention to the concept of scoring units. And for the date of the final examination, you have to make sure that you have the necessary requirements, or you have your computer, you're connected to the internet. There is also a you have webcam, or either internal or you bought your own whatever external USB. It doesn't make a difference, but it has to be operational. It has to be working. You have a microphone. You have a way to call a number either by a cell or a landline. You get all the requirements that are stated there when you sign up for when you schedule your final examination. You cannot have anything on your desk. It has to be completely clear of anything. We'll be able to verify all that. Any type of thing that you have on your desk could be grounds for you to get an automatic F. You will forfeit the exam. So we will verify. You have to have an ID as well, because we need to verify your identity. And it is, even though you're doing this from home, it's in a very controlled environment. And there will be, first of all, someone from our IT department will connect you and go through the first part of this exam and all the necessary protocol, like checking your identity, checking that you're not recording the exam, and so on and so forth. And you need to have headsets as well. Keep in mind, you need to have the headsets and have them on. You will not be allowed to take the exam without headsets or headphones or headsets, whichever. But in other words, the sound should not be projected in the room where you're taking the exam. And Then after that, you will be transferred to a proctor, and the proctor will go over, will basically give you the instructions to take the final examination. And you will, in the candidate's handbook, it also tells you what are the possible grades and so on and so forth. And that final examination will give you the grade for this class, for this training program. It's required that you get 70% or better to be able to start interpreting to be allowed to interpret for the first time in immigration court. So it's important. If you score between 60 and 70%, you can retake this training program and retake the final examination. Of course, it will be a different one. And see whether you can score 70% or better, okay? So having said that, this is basically the end of lecture number 6 and also the end of this interpreting training program. I hope you enjoy the program and that you do very, very well in your final examination and very, very well, hopefully in immigration court, if you successfully pass our final examination and move on to interpreting in immigration court, and also pass their first evaluation. There is a first evaluation, I believe, that you have, that they will do there live of the first hearing. So it is in your best interest to do as much practice as possible before your final examination and to study all the vocabulary and everything that we discussed in this training program. Okay? Thank you very much, and good luck.